The Honorable, the Supreme Court.
Good morning. Thank you all very much. Please be seated. And please go ahead and call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont v. Larry Labrecque, case number 23AP284. Representing the appellant, Larry Labrecque, is attorney Allison Fulcher. Representing the appellee, the state of Vermont, is attorney Travis Weaver.
Okay, thanks very much, counsel.
Good morning.
Good morning. Please, for the record, if you would, identify yourself and your client.
I'm Allison Fulcher, and my client is Larry Labrecque.
Thank you.
At trial, Mr. Labrecque was facing a 3-count information. It was prosecuted as 2 aggravated sexual assaults and then a lesser included offense of sexual assault for the alleged assault that occurred on May 14th, 2018. The jury acquitted him of both the aggravated sexual assaults and found him guilty of the lesser included sexual assault. What was the key difference between the aggravated assaults and the sexual assault? What key piece of evidence did the state have that they didn't have for the other? Was DNA evidence. That was the key to the state's acquiring the conviction for the sexual assault. Yet the state never disclosed that their expert would opine on.
So, Ms. Fulcher, I'm going to ask you a question. I apologize for interrupting you there. But I'm curious as to your position that the reason the jury acquitted of the higher offenses was because of the DNA evidence. Do you come to that conclusion because there were jury notes sent out that the jury may have been asking questions specifically about DNA and its impact on some of the evidence? And how do you know that?
Well, there was absolutely no DNA evidence to support the aggravated sexual assault charges, the repeated, and there was the DNA evidence for the sexual assault, and that in itself, it's just very strong, compelling evidence. If you have DNA evidence, you don't have DNA evidence. It is very strong, compelling evidence. It is certainly a key piece of their prosecution, and it was.
So it's your inference, correct?
Correct.
Okay, thank you.
And your main concern seems to be that you didn't have notice that the state's expert was going to testify it was more likely that it was a direct transfer. But there were depositions of the expert, and one of them, I don't think it was you, but the attorney below asked the question, isn't it more likely that the DNA got there from laundry? Isn't that question in itself saying it's not more likely that, insinuating it's not more likely that it was a direct transfer? And so how can you say you didn't have notice of this issue or his?
You didn't have notice that the expert would give an opinion as to it being more likely. You're correct. That's the question that was asked in deposition. And at trial, he said, it's more likely that it got there by direct transfer. And then when he was cross-examined on that, said, did you ever give that opinion before? And he goes, no. And he goes, but I wasn't asked that specific question. He said, I was asked about possibility, not probability. And in fact.
So let's accept your position, and I think I do, that a question was asked and not answered in that position. Isn't it your problem to re-ask or whatever? I mean, trial counsel is Carol indicated. Don't you have to follow up when you ask them a question they don't answer in order to get an answer?
Well, he did get an answer. He got an answer that it was a possibility.
Right, but it wasn't an answer. Just following your
right.
It asked for, isn't it more likely? So the question was beyond possibility to probability, but there wasn't a probability answer. If that's true, isn't it your responsibility to chase that? So that you get the answer to the question that you wanted.
Well, I think trial counsel did, because then the trial counsel asked him the alternative question. Then he said, so the same could be said, true, that it was coming from a sexual act too. It's an explanation, but it doesn't mean it happened. So he asked it again. So what you're saying is these are all possibilities, but you are not opining to me on probability. And the defense expert was clearly gonna come in and say, you can't, DNA is everywhere. You can't.
Other question, whether there was any consequence of this, if you are gonna have a defense expert.
Well, sure, you've got
Address the specific question you were talking about.
well, yeah, you have competing expert testimony. And if you're going into trial thinking that both of them are gonna say it's a possibility, but you can't, there's no way we can discern which one's more probable, then you have two experts that are saying the same thing. And and your expert's gonna go on and say, this is why, and go on and explain why it can't give you probability. Now, all of a sudden, going into trial expecting that both of them are gonna say, well, it's a possibility, we can't give you probability. That's just, we can't do that. We're not capable. All of a sudden, their expert comes and says, oh, yeah, it's more probable. And when he's questioned about that, well, how are you saying that now? You were asked that question before, and he goes, well, I wasn't asked that question, but he was in fact asked that question.
And so you did call an expert,
Mhm.
the expert addressed the issue, disagreed with the state's expert. What more could be done? I mean, how do you
In
argue,
their
you had,
expert.
how could you argue that this was harmful versus harmless?
Because you knew going in that both of them were gonna opine about the possibility. But now all of a sudden you have the state's expert coming in and telling the jury it's more probable. And then you weren't allowed to directly impeach him on that statement. Why?
Well, how
can't I
far
bring
does
in
it-
that position?
How far does one need to go as a witness in a deposition before you're arguing that there's no notice? I mean, so you're saying this long deposition happened, it was mainly, or at least in part, about how this transfer was made.
Mhm.
And he said it could have happened that way, it could have happened this way, but he used a different word in the trial.
Mhm.
I mean, what's the cutoff as to
Well, if-
when it's okay and when it's not to add a different word in your testimony?
Well, I think the defense had the right not to let it just sit. You gave me I asked you this question before, you gave me some totally different answer. I asked you in front of the jury today, you gave me, yes, it's more probable to be direct transfer. And then you can't challenge that statement from that expert. Yeah, you have your expert coming in, you have two competing experts. But now you've got the state saying, yeah, we're gonna talk about probability. Mine says you can't talk about probability. And yet I can't go back and say, well, look, we talked about this before, and you couldn't say anything about probability. All of a sudden now you can. And maybe that's the end of it.
Clear, are we talking plain error here?
No,
We're not on plain error, there was.
well, the constitutional issue, raising it to the point that all these evidentiary issues were raised, but there was never argued even in the motion for new trial that they actually rose to the level of.
So just to be clear, the argument that you made in the brief and your argument today was not preserved.
He was denied a fair trial. That's specific constitutional, it was not.
Preserved.
Right.
But are you talking about the you've made a cumulative?
Right, so in below, we made the cumulative effect of it denied him, it's, I think it was a miscarriage of justice was the term that was used. But what we're saying on appeal is that these are the two specific evidentiary issues that were raised and preserved, but they were never asserted to the trial court as, I was denied a fair trial. You denied me my ability to present a defense under, constitutional rights. That was not specifically, but the actual evidentiary issues that we're talking that rose to the level of denying him a fair trial were raised. Just wanted to be clear that actually telling the court that you denied me a fair trial and that, I had, this constitutional right, that was not specifically preserved. And then moving on to the other piece, which is the issues with respect to Detective Adams. And to present a complete defense, Mr. Labrecque had the right to question the lead investigator about the investigation. And he couldn't.
He could have, he just wasn't very, didn't exercise any, well, he didn't try very hard to get her there.
Okay, well, that's debatable because at jury draw, trial counsel asked the state, are you gonna be having Detective Adams come and testify? We're not sure.
And the defense said, we're not sure too.
And they said, okay, well, we're not sure. And then when they found out, or they decided that maybe we should just subpoena her and have her available in case we want her to testify. So they sent out their investigator. And I would say that the investigator did a pretty aggressive job on that Saturday after they found out that the state was not going to call her, of trying to subpoena her.
And that was 2 days prior to trial.
That was 2 days prior. And there's a lot of conversation in the court saying that was the only attempt. There was one more attempt, and it is in the transcripts that the last day of trial, their investigator did make one more attempt. So, and that was unsuccessful. And that is in the trial transcript.
She was lead investigator,
She was the lead investigator.
but substantively, what exactly was her involvement?
Well, as the lead investigator, and I guess, part of our defense is that it was very little, but she did more than any other detective. The two detectives that testified, or the police officers that testified, neither one of them had any involvement. One drove the complainant to the SANE exam, and the other one, I think, was responsible for, DNA evidence, putting in the locker, and actually was there when the lead investigator arrested Mr. Labrecque. But other than that, they had absolutely no involvement. She was part of, what is it, the SIU or whatever. They specifically had to seek her out to take over this investigation because she was the special investigator for these kind of sexual assaults and everything. So she took over the case. She was the one that then started putting the case together. And, part of the defense, what we're saying is we wanted her to testify because of what she didn't do. She never,
Can I just interrupt? You say you wanted her to testify, but you didn't make an attempt to subpoena her until a weekend,
Right.
2 days before the trial, not knowing whether the state would call her, and on the record, the defense attorney not knowing if they were going to call her. So if she was so important, as you're saying now, why wasn't she subpoenaed months in advance?
Well, some of that I think develops, trial. As the trial goes on, your need for certain evidence or other evidence, changes. It's a fluid process. So they weren't entirely clear whether they needed her, and they kind of were, inquiring about it at jury draw because, starting to put the game together, trying to figure out how we're going to do this. And then they did try again on the last day of trial, and that again, because, the trial's fluid, things happen. And at that point, the way the case was going, they did feel that they needed to bring her in and question her
But Ms.
about her investigation.
Ms. Holder, I don't understand how a judicial summons would have helped, because my memory of being on the trial bench is, number one, that is only issued for a defendant to appear before the court, and number two, it's by mail. So how could that have helped you?
I
make
agree.
an request on
I
that
agree.
trial?
That's why we didn't raise that on appeal, because I don't believe that a judicial summons could issue or would issue in this, or would help in any way. So, it's not necessarily that, the court didn't take that step, but, where the problem came in is when the court wouldn't find her unavailable at that point.
Thank you.
Yes. And so when the court wouldn't find her unavailable, they couldn't use her deposition testimony. And then the court also said, well, you can't, she's not unavailable, so I'm not gonna allow you to introduce the deposition, but you can ask the other officers about that, which the court claims he never did, which in fact he did.
About the investigation.
About the investigation, and both of them said, we didn't have any involvement in the investigation. That was Detective Adams' job. She was the lead detective. She did all that work. We didn't have any involvement. So, Mr. LeBrecq did try to get some of that information out of the other officers, and they were not able to give that information. So, if there are no more questions, I will just sum up and say that not being able to challenge Mr. Abraham's new opinion, which said that that Mr. Labrecque's DNA found on AG's underwear was more likely to arrive there by direct transfer as opposed to secondary transfer, and not being able to question the lead investigator or explain her absence from trial, and for the reasons that she was terminated from the police force for dishonesty and dereliction of duty, which occurred during the pendency of this case, denied Mr. Labrecque the ability to present a complete defense and therefore denied him the right to a fair trial. And for the reasons that we stated today and in the briefs, we'd ask you to reverse Mr. Labrecque's conviction.
Okay, thank you very much. And we'll hear from counsel for the appellee, please. And if you would introduce yourself and identify your client.
Thank you, Justices of the Supreme Court. My name is Travis Weaver, Deputy State's Attorney in Windsor County, representing the appellee state of Vermont.
Thank you.
I do want to start by responding to some of the arguments now made about Detective Adams. And I think some of the lack of efforts made by the defense at trial to produce her were noted, but I do think that actually understates what they conceded at trial. When this was first raised, I think on the first day during motions in limine, they conceded even when they decided to subpoena her, before then they had never intended to call her as a witness, and that even when they did try to subpoena her, it was just in case. Noting that just to highlight that at the time the trial was unfolding, it did not seem to the defense that it was that important, and nothing arose during trial that would have changed that. Indeed, if you look at the transcripts that I've quoted in my brief, they struggled to produce an articulable reason that her testimony was necessary. They started by saying, we want to show what she didn't do. There was never any dispute about certain actions not being taken by the police. So a lot of what they're pointing to would have been good impeachment evidence so if we were relying on her credibility to say, oh, I did do that. But that was never in dispute. And indeed, over time, it changed. And by the end of the trial, they were saying that they needed her testimony to impugn the entire police department. I've made my arguments that that's getting pretty inflammatory and could be used in any trial where any police officer is terminated. That doesn't mean the police department themselves are faulty. The defense was invited to connect the dots to say, how did this relate to the investigation? The defense conceded it didn't really have anything to do with this particular investigation. And the judge was therefore justifiable in excluding the evidence under 403. But more than that, when we were talking about the deposition transcript and could that be produced in lieu of her testimony, the defense couldn't even point to a part of that deposition that they wanted to have introduced into evidence, and they were given that opportunity. So it's hard to say now that just because the judge ruled she was unavailable, thus sidestepping that issue, again, the defense couldn't really point to a critical part of that deposition that they wanted to utilize. I have a few more things to say about Detective Adams if I have time, but I want to turn to Mr. Abrahams because I think some of what he was asked and some of his answers got muddied in the oral argument today. I think it's important to highlight that he wasn't asked, he didn't refuse or avoid the question of is it more likely that DNA was transferred directly? What he was asked directly during his deposition was, is it more likely that DNA was transferred via indirect methods, such as laundry? And in his deposition, in that portion introduced into the trial, he clearly disputed that. He said, like I said, that's an explanation, but that's not what, doesn't mean what happened. When you're dealing with two possibilities, direct transfer or indirect transfer, if he's saying at the deposition stage, I don't think it's more likely that it was indirect, he's necessarily saying that he believes it's more likely it's direct.
But I thought he said in his deposition that everything was possible. I thought he was, in a way, generalizing this information such that when it became more specific at trial, there was a basis for impeachment.
So again, during the deposition, he was clearly contesting that it was more likely indirect. And then the defense attorney asked him, well, isn't anything a possibility? And he says, correct, like anything's a possibility. He was never asked a follow-up question about the probability. And again, if you're dealing with two possibilities, saying one that's unlikely makes the other one likely. Unless you have more than two, I would argue it's a mathematical fact. And indeed, the defense
Mr.
itself.
Weaver, let me just ask you a question.
Sure.
I was like a ventriloquist, huh? You thought I was over there on the other side. What's the difference between possibility and probability?
Sure, something that has a 1% chance is possible. I don't think that's what most people think of when they say is it probable. I think most people, I'm not saying there's not some fuzziness to these terms, but I think in layman's speak, if you're saying, hey, this is probable, it means more likely than not, 51% versus 49%. And the point I was just about to highlight is the defense didn't act at trial like they were surprised by this opinion. And I think that's something important to stress. This was not a surprise that all of a sudden we're talking about probabilities. They retained an expert. Their expert was going to talk about probabilities. They knew from this deposition what Mr. Abraham was likely to say. And indeed, they never argued at trial that this was catching them by surprise, that there had been a discovery violation. That was an argument that they only made after trial. What they were trying to say at trial was that it was inconsistent with what he was saying at trial. And again, Judge Treadwell listened to the deposition and ultimately decided this is in no way inconsistent with what he's saying now. He rejected your theory that it's more probable coming from indirect transfer. He acknowledged that both were possibilities. And now he's saying that yes, in line with me saying that it's indirect is unlikely, direct is more likely. The state would argue it was within his discretion to say this is not something so inconsistent that you should be allowed to impeach the person. And then if we're getting into discovery, the motion for a new trial was rejected because the judge found there was no prejudice. In my brief, I argued both. There is no prejudice. The defense cannot point to anything they would have done. They asked that follow-up question just to connect the dots. And they knew for a fact that he was going to say it was more likely direct transfer. They'd already hired an expert. That expert was already primed to testify on these exact points. The trial court never reached the issue of whether there was a discovery violation in the first place. I've argued under State v. Provost that we're so close to what they're talking about, the defense is expected to make reasonable inferences from the information they have.
Mr. Weaver, if the defense wanted to convey to the jury that Detective Adams was negligent in her investigation, could the defense have elicited those types of questions from the law enforcement officers who were testifying on the defense's cross-examination? I'm sorry, as in a convoluted way, but could that evidence have come from the witnesses who testified on behalf of the Harvard police?
So, but I think I'm only stuck on the word negligence. I think it was.
I'm sorry, not negligence, did not adequately conduct the investigation.
Yes, Your Honor, and I think even the defense during the motion limine stage acknowledged that. The trial court asked them, can't you get in what steps were taken and not taken through these other investigators? Yes, you could. And I think at that point, they shifted gears. Once they acknowledged, yes, we can establish that certain steps probably should have been taken. And I was going to say they could at least argue negligence. I mean, the fact that photographs weren't taken of the scene probably should have been taken. But no one was disputing that that wasn't done. That was something that everyone was going to say. We don't have photographs of the scene. That wasn't done. If you want to blame the police, it doesn't really matter if you're blaming Detective Adams or the department as a whole. The fact is that wasn't done and no one disputed it. It was kind of one of those things where, from the state's perspective, you get 3 detectives in and the one that doesn't show up suddenly becomes the most important one. The reality is everything pertaining to Miss Adams isn't substantive evidence that they wanted to get in. It's impeachment evidence. It would have gone to her credibility. It would have gone to her dereliction of duty. It would undermine any testimony she had offered about steps she had taken. But the fact is, she didn't produce a lot of substantive evidence in this case. I argued at length in my brief that that's not at all uncommon for sex assault type cases, especially ones that are somewhat delayed reporting, where the event may have happened some time ago. It's not always clear what steps, even if we want to characterize it, a lead detective can take. A lot of times they're collecting the evidence from other witnesses with firsthand knowledge. They're presenting it in an affidavit, and those are the witnesses that get called at trial.
So she was fired for falsifying evidence? Is that right?
I don't believe she was falsifying evidence. If I recall correctly, she reported that she was going to go to a scene and that she was nearby the scene. And in fact, she was in the state of New Hampshire dealing with some personal matters. So that was considered a lack of credibility. I believe there was one other incident about, I want to say timesheets or something like that. I know I briefed it in the footnote in my brief. But even the defense acknowledged that the things that she was terminated for didn't have to do with investigating cases. They certainly didn't have anything to do with this case. And the trial court gave them an opportunity to try to connect those dots. Is there a way to connect what she was fired for towards her maybe a propensity to have done certain things incorrectly in this investigation? And they couldn't connect those dots. Part of what I argue is that that's how the trial court looked at it, as a propensity matter under 404B and 403, but it's more than that. Because the defense wasn't really arguing that she did or did not do something because of these traits. It really is an ad hominem attack on the whole police department. And the way they phrased it is, her termination goes to the credibility of every officer in that department. Again, the trial court has some discretion to exclude inflammatory matters under 403, even though the defense has a constitutional right to present a defense. I think the trial court was correct in determining that that was so attenuated and so inflammatory and would open up so many issues that didn't have any direct connection to substantive evidence that it was appropriately excluded under 403. And again, as I started my argument, even the defense, if you had asked them then, not today, but before the trial, how important is it to you to have Detective Adams testify to this, they would have said, we're not even sure we're going to call her. They said that the day the trial began. Now, I know they made one last attempt in the last day of trial, but that's after multiple admonishments from the trial court saying, hey, if you really want this detective here, show me some more information. He invited them to call the process server. The process server didn't testify. They read an email. I guess I would dispute the appellant's characterizations of the efforts, but it seemed like he showed up at her house and gave her a phone call. And all that he did is he reached someone on the other end. We don't know if it was the correct phone number. He said, I can't help you.
There was some comment in the record that the officer we're talking about refused to come to court, but is that true? I didn't see that. I saw that she said something like, well, I can't help you, or something like that.
Certainly the defense has characterized it from the beginning that she was refusing service or evading service. And part of what I tried to highlight, I mean, I can't say 100% that I know for a fact that's not true. All I know is we're talking about a witness who 3 days before trial, no one had attempted to subpoena her. We don't know if she was in the state of Vermont. We don't know if she was home. There's no evidence that I've seen that suggests she was avoiding service.
And we don't know who made the statement, I can't help
We have the process server who stated via an email, read into the record, that he believed it was Detective Adams. We have no reason to know that that's correct. And even if it had been true, if she's on vacation out of state, there's a perfectly reasonable explanation to say, hey, look, you're trying to subpoena me 2 days before trial. I'm not there. I can't help you. Again, I don't know. It's not in the record. I'm sort of speculating here. But the whole point is, if you're now going to say that this witness is so critical to your defense, I think, as Your Honor's noted earlier, that subpoena should have gone out well before 2 days. And again, even when asked about that issue, they said, well, we're doing this just to be safe. We don't know for a fact we want to call the detective. And there was some argument earlier about, well, the trial as it evolved, but I would challenge the appellant to point to anything that developed during trial that wouldn't have been known before trial. The steps that weren't taken, that was known well in advance. The credibility concerns of Detective Adams, that was known well in advance. There was nothing that arose during trial that said, oh, we really do need this person. And even if that had happened, you would have expected the defense, well, before trial to ask for a continuance, or during trial to ask for a mistrial based on some development that this person was so critical. It was really only after the fact, after the conviction and the motion for new trial, that became a focal point of their arguments. If you looked at how these arguments were presented at trial, the importance was much less important to the defense than it is now on appeal. And I think Your Honor should keep that in mind in considering whether or not the defendant's constitutional rights were violated. If there are no other questions, I will end my remarks there.
Okay, thank you very much. Is there time left for the appellant?
Appellant has no